Hey, right, everyone, welcome to this week's live stream. Sorry we weren't around last week. Something came up for me and it just made it a bit of a hassle, really. So, for those who haven't been to the live stream before, we're just going to do our best here to be useful. This isn't legal advice. We're going to try and take questions that have either come in through the week, and I think there's been three questions that have come in through the week, and also pick up questions that come through the live stream directly. Please don't share personal data in the chat. Don't ask questions about your own situation. Just ask them as if they're about someone else. You get the same answer, but you don't then have to put all your personal data onto the internet to get the answer. And keep the questions kind of contained. So try not to sprawl them over lots of information. Just try and kind of separate out the questions into discrete, smaller questions, if that makes sense. Um, feels like there's been a lot of news around this week, but the only thing I can think that's relevant to housing is the whole Renters' Rights Act is now got royal assent, if that's the right word. I don't even know how it all works. But basically, the actual ending of Section 21s and that sort of stuff won't happen for another 6 months or so. It's not, I looked at today, it's not been set yet. So Section 21 still exist, and you can still get compensation if you get told to wait until the bailiff comes. So yeah, there's that. There's also, I just um, attended a Garden Court Chambers webinar, which if you don't follow them, you need to follow them because they're great. There was a couple of barristers there, and they were talking about challenging out of area placements, which is something that comes up a lot on the live stream. And we tend to kind of like wriggle out of it and kind of say we need to do a proper video about it sometime because it's quite complicated. But if you go on YouTube, Garden Court Chambers has its own channel, and I would imagine within a few days they'll have uploaded that session. So check it out. Basically, I forget the first barrister's name because I've not heard him before, but the second barrister was Nick Baddow, and he mentioned that there's the new edition of housing allocations and homelessness is coming out on the 4th of December, which may not excite you guys, but definitely excites me because that is the best textbook. And I noticed that so Jan Luber's still the primary author, but it's got Liz Davies and Nick Baddow and someone else as well. So it's the most comprehensive textbook, and it's also written by people who actually want to house people. They actually understand that the spirit of the law is to house people. So yeah. Um, Other than that, me and Will did a webinar. We ran a webinar on Tuesday, went down well. There's another webinar we're doing a week on Tuesday, so the 25th of November, which is all about kind of focusing on homelessness law and the criminal justice system. So it's kind of aimed at probation officers and prison officers, but it's open to anyone. It's free. If you look on Eventbrite and search for homelessness best practice, you'll find our page and you'll find the details of it. And at this point in time, yeah, there's the only training available that's available for booking is the 5th of December, the introductory course. At the moment, only two people have signed up, so I might well cancel it and postpone it till the next year. But we'll see. Yeah, check that out as well if you're interested in getting the whole day's training. But yeah, other than that, that's me waffling on enough. Any news from you guys of significance? Or Will looks like he's got something.
Much. I could say I had a bit of, I could give you an example of some horror stories from the courts this week, just in terms of bureaucracy. Um, and it shows you the difference between the High Court and the Administrative Court, which does judicial reviews, and the County Court, which does homelessness appeals. So this week I had to issue a judicial review to try and stop somebody being evicted from his temporary accommodation that day by Croydon Council. And I sent the papers into the court in the morning by email, 100 and something page bundle. And I said to them, can I have a decision within 3 hours? They'll put it in front of a judge within 3 hours. And they are incredibly good at that. And unfortunately, by about 2 o'clock, actually that was what was happening, Mike. It was during the beginning of the webinar. I got a phone call from one of the senior lawyers at the administrative court to apologise for the fact they were having difficulty getting it in front of a judge. But they said, we'll keep trying, but we just wanted to check if the council had backed down, because sometimes they do once you say, right, we've issued. And so I said, wow, I'm really impressed that, I mean, it's a worry that you might not get in front of a judge, but you've actually called me to tell me that. And then the council did back down. So I called the woman at the court and told her this. And so she said, thanks, the judge will be very pleased he doesn't have to look at this. So that was an example of how fantastic the administrative court is. Meanwhile, 2 weeks ago, no, probably about 10 days ago, I sent some papers to the Central London County Court to issue a Section 204 appeal. Now, this was the one which I mentioned before, where the decision letter was 76 pages long. There was Section 184 notice. Because but anyway, the bundle of stuff that I sent to the court in the event must have been about 100 and something pages. And then a week later, I get an email from the court saying we've rejected your application because the rules say that you can only send up to 25 pages and 10 megabytes, and your documents are more. So we're just rejecting your application altogether. And I noticed to my horror that the day that they did this was the one day before the 21-day deadline to appeal expired. So I had to arrange for somebody to print off hard copies and take them to the court and drop them off. I sent an email message to the person who'd sent the message saying, well, can't you just issue it based on these bits? And I didn't get a response. Oh, no, I did. I got an automatic response saying it's taking us about 30 days to reply to emails. But the punchline to that story is the next day I sent something to Clerkenwell and Shoreditch County Court. And I always believe that with local authorities and bureaucracies generally, if you want to get a fast response, make a mistake when you write to them. Tell them that if you want them to acknowledge receipt of something, don't bother putting one of the attachments on. And then you'll get a response back immediately saying, you got it wrong. So I got an email message within about 9:05 a.m. from Clerkenwell saying you didn't attach anything. Now, if I had attached it, I wouldn't have heard from them for 3 weeks. But it's just an example of number one, how the county court rules are ridiculously outdated, that you can only submit 25 pages worth of documents, um, and that they can just reject things out of hand like that when they set a 21-day time limit.
Right. I've got various questions about this, Will. So, first question is 76-page long section 184. Was it just nonsense, or how? I mean, what was it? What have
Well,
they? How do they do
yes.
that?
In a nutshell, yes. Much of it was nonsense because the housing officer appeared to have gone through the person's file and just said everything that had happened. And this was an application that had been going on for 20 years since they first applied somewhere else. And it was a long running case, but the whole history was in there. But I think that I've noticed this coming from other local authorities that I think the software that they use, it may be part of this jigsaw system or one of these other things, has been enhanced lately so that they can copy and paste images from other documents into their decision letters. So they'll be copying huge chunks of other documents in. So it was mostly rubbish. I mean, the part of it which was, that thing, if you know what you're talking about, you can say it fairly succinctly. And if you don't, you have to go on forever. But the bit that was sort of the core bit could have been done in about 5 page, well, 3 pages. The good news is the review decision. They got that one down to 35 pages. Um, but yeah, I mean, it's ridiculous. Um, but oh, and it's so crazy as well. On that one I did where the one where the High Court rang me up, I've been fighting with this council of Croydon to withdraw this decision. And as soon as I issue, it was a case where they'd done a negative 184, and then they weren't doing a review in time. What I forgot. But as soon as I told them I was issuing, bing, they withdraw the Section 184 notice and say, okay, we'll look into housing. But I have to go through all that to issue it.
Can
And then
can
they
you?
tell me it's academic and they shouldn't have to pay costs.
Sorry, Shannon, go for it. I was gonna. I've got.
No, I was just like, one, it doesn't follow data minimization, does it, to have a stupidly long document like that? So arguably it's breaching the Data Protection Act. But two as well, what blows my mind is did you change the length of document when you gave it in person? Or is it literally just like the attachment's too big for our system? But you can still submit this ridiculously long document.
Yeah, I mean, they received them all and they had them
Right.
on the system. But they simply said because they're working on the basis that it's sort of still 1992 or something, and that what you do with an email attachment is you print it off and then put it on your hard copy file. So they
Oh.
wanted me to send three. I have to send the original documents and 3 copies, no, 2 copies. So it was just ridiculous. I mean, most of the time with Central London County Court, they don't play that game and they don't enforce it strictly. But I think once they saw, if I'd sent them like a 10-page letter and I'd gone slightly over the limit, they'd probably be okay. But I think when they saw 76 pages, it sort of blew their minds and they went back to, no, we don't want to deal with this.
Do you think it's just really
It's
savvy housing officer who's just like, well, if I put 76 pages in, it's going to screw up the chance of getting judicial reviews or whatever, and just kind of give us advice a
Yeah,
bit more time?
I think there's an element to that. I think that you sometimes get this with barristers in court. They just go on and on and on and on, and you think that they're just trying to bore everybody into submission. And you think, okay, okay, just shut up and I'll give up. And I think there's a little bit of that was going on. Plus, they think, well, if I just sort of throw enough dust in the air, nobody will see what's going on, and they'll say, well, he's obviously thought about it very hard, so we won't challenge his decision.
And can you ever like charge a council so in the case of Croydon you mentioned, like where they're wasting your time, they're waiting for you to actually issue before they back down? Can you just bill them for it and say, well, this is taking me like 10 hours of work here. You could have just backed down before and just kind
Well,
of.
that's right. I mean, actually, to their credit, Croydon, well, the person at Croydon Legal Department who sort of got the thing dumped on their desk that morning said, "Can you let us have an idea about what your costs are?" So they knew they were going to have to pay. But the person from Hounslow, who I'd been fighting really hard with on another case, had the cheek to tell me, having backed down completely as soon as I issued, then tell me it's academic. And I said, the only reason it's academic is because when I issued proceedings, you did what you'd been
You housed
refusing to
them.
do,
Yeah,
gave accommodation. And so I'm waiting to hear back to that one. But
yeah,
it's just you can never underestimate how unhelpful these people are. You just have to sort of plod on but it is nice that the administrative court. I could name drop as well that the I did have to call the Supreme Court this week about a case where I'm trying to get permission. And there, I mean, if you ring the county court, you get put through to a caller centre somewhere in Peterborough or something, and they won't let you speak to anyone at court unless it's an absolute emergency, and you've got to prove that there's a hearing the next day or something. And otherwise, you just get somebody reading a computer screen saying, "Oh yes, your case is in the Central London County Court, isn't it?" But the administrative court, you might get through to somebody, but you'd have to hold and listen to a lot of messages. But the Supreme Court, you literally ring up, somebody picks up the phone and says, "Can I help you?" And they actually deal with it straight away, and they're really helpful. And so, yeah, I mean, the higher you go, the better it gets. Although the court, yeah, even the Court of Appeal is quite nice, but the county court, I mean, it's just classic underfunding, really. I mean, they're just
yeah,
struggling.
yeah. That
Say
in for your
Bromley
job.
Bromley County Court is really good. I have to wave the flag for them. They will respond to emails in a helpful. They actually, yeah, they're really good. And I hope if anyone from there is watching, thank you very much.
Yeah, cool. Um, cool. I need to. I've got more questions for you, Will, on that in terms of like what are all these different court? Because you mentioned the administrative court, which I've never heard of before. Um,
Oh,
but I'll save it for another time. It's all right. I'll
yeah,
let's
yeah.
stay on track for the time being. So yeah, this is there's as I say, three questions that come through the week. This is the first one, probably the most yeah, kind of complicated one, but really very good question. So let's start with this. So number yeah, can you give can they give you section 184 before the 56 days relief period that expires? That's what they're kind of talking about there. I've now only got 4 days remaining, but have asked for the past 2 weeks for a decision. They have letters from my doctor, mental health assessment, and mental health crisis team also wrote a supporting letter. They're still saying they have no reason to believe I'm priority need right now, but won't give me a section 184 letter so I can do a section 202 review. So it's a really good question and quite an interesting answer, slightly complicated answer. So let's just kind of give ourselves a bit of context here to explain how this works. You make a homeless application by giving the council reasons to believe that you might be homeless and asking for housing help or help with getting housing. And essentially, really, the first question they need to answer is there reason to believe that you might be homeless, might be eligible for assistance, and might have a priority need? And if the answer is yes, you might do, then they have to provide interim accommodation immediately. So it's called Section 108. And at that point, the only way that they can then kick you out of interim accommodation before the final decision is reached approximately 56 days later is to issue a Section 184 non-priority decision. So, and that will bring with it the right to review, get a review of it through the Section 202 process. Now, so that kind of that is it's clunky, but that kind of that in one sense that gives you access to kind of an appeal or whatever. The problem you get is where a council just pig-headedly denies there is any reason to believe that you might be in priority need. And clearly, if you've got a case here where someone's involved with the mental health crisis team and has got other evidence as well, there is no way on earth that there is not reason to believe that that person might be in priority need. I'll go on a slight tangent here briefly because it's something I'm going to return to later. But Bedford Borough Council has been using a template Section 188 decision. That's not a real thing, but they're using this letter, which is kind of called a Section 188 decision, and it actually mixes up the threshold. So it basically says, there's no reason to think that you are in priority need, and kind of and kind of dismisses everything out of hand. Now that's not the test. The test is any reason to believe you might be in priority need. There's an interesting case called IA versus Westminster, not that long, it's not only a few years ago, where someone presented with some complicated mental health issues, among other things. And in that case, the judge basically said, in order for a council to complete their inquiries, they need to have spoken to present and past treating professionals, psychiatrists and stuff. They need to have shared all the information and kind of put other things to the current treating team, and even commissioned their own psychiatric report themselves. Not, that's not just kind of getting now medical to write a letter, but actually, kind of getting an assessment done before they can be satisfied that they're not that person like that would not be in priority need. So the problem you got here is that the council is simply perversely denying the obvious, that there is obviously reason to believe this person might be in priority need, but it's actually quite difficult to challenge, particularly if we're talking about a London council here. I've challenged it in Bedford simply by complaining, which technically shouldn't work because technically complaints is a different system, but because we've got pretty good standing in Bedford in terms of having made lots of complaints before, they do take it seriously. So that was, I mean, I remember that time was back in 2020, and I just literally complained about the use of this template letter. However, they're now using a fresh letter, which I don't even know where they got it from yet. I've FOI'd it. But that's really the problem you got here. So legally speaking, the only way you can challenge this is to get a solicitor to threaten judicial review, effectively, of this council's refusal to provide Section 188 accommodation and accept that there might be reasons to believe that that person might be in priority need. So I've probably got a bit more to say about this, but does anyone want to just kind of add anything to what I've said already, or kind of clarify anything I've just said?
I think just on the supporting letter thing, because I know we've mentioned it before around when GPs write supporting letters, but it's what's really crucial is that supporting letter includes like what might happen to you if you became homeless. So the effects of your mental health conditions, the effects, any particular harms that might happen, and it might be stating the obvious a little bit, but I don't think it is, particularly to professionals. But a ramping up of depression is a harmful effect. More suicidal thoughts or more anxiety, more panic attacks, not having a safe space, whatever it might be, that's a harmful effect. So an increase in sort of anything like that would count as a harmful effect. And so when you say supporting letter, it might be a really, really good supporting letter, but I think we've probably all seen supporting letters where actually the crisis team have said, look, this is Joe Bloggs, they have X, Y, and Z diagnosis. Please help him with housing. And that's not as good as it could be. So it's worth having a conversation if you can with the mental health crisis team and just saying, look, I think Mike, you've probably got about four other videos on the channel and you'll probably know the name of them, but what sort of evidence do you need and how to lay that out? Because there's a couple of different bits of case law that you can use to sort of lay that letter out.
Yeah. Um, there are a couple of videos on the channel. I mean, this is also a big part of the priority need training I do. So yeah, yeah, Shannon's just nailed it really. So supporting letters don't necessarily hold any water, although I would say that a letter from the mental health crisis team listing diagnoses would be reason to believe that person might be in priority, because what it basically means is that the officer has to then make inquiries and find out, okay, how are these diagnoses being managed and what's going to happen to them. As Shannon says, if that person was to become homeless. And I guess technically speaking, if you've got, you might have a diagnosis of schizophrenia, but your medication is 100% dealing with the symptoms, then actually that might take you away from that threshold of being in priority need, because in one sense the council is at liberty to take into account the support that's available. I just can't see anywhere on earth that someone who was under the mental health crisis team would be in that boat. They're going to be someone who is by definition in some sort of crisis.
But
Shannon?
if homelessness, if all like potential homelessness was to mean that it's more unlikely that you can manage your medication, that would then become a factor as well. So
Yeah.
even if you're like I hate this like phrase, but like functioning fine, but you have all of these sort of things going on, which you probably wouldn't be under the crisis team anyway for. But say that was the case, actually, if becoming like homeless in whatever capacity was to mean that managing your prescription or your medication or whatever is more difficult, then that would still be a relevant factor.
Yeah, I think it's really unimaginable that someone who is under a crisis team, there would not be any reason to believe they might be in priority need. It's just absurd. But councils get away with it. The charity sector allows councils to get away with it. They don't challenge councils. There aren't enough solicitors around to actually kind of, hold councils to account really. So that's kind of why we've got to this point where a housing officer can, with a straight face, kind of take that position. So yeah, in terms of helpful advice, try really getting a solicitor is going to be key here. If you go on Will's website, I'll get a link to it in a minute. Stick it in the chat. In fact, it's in the usual description as well. But Will's compiled a list of legal aid funded housing solicitors that may have capacity. A lot of them won't have capacity, but that would be the most straightforward way to deal with it if you can get a solicitor. If you can't get a solicitor, as a non-lawyer myself, as an advocate, I would just be complaining robustly, stating what the law is, quoting these bits of the kind of cases like IA versus Westminster, and just kind of make the point that this is really quite unbelievable that a housing officer would reach that position. But if you're making that complaint for the first time to a council, you never made it before, you definitely do have an uphill struggle. So it's just one of the ways in which priority need is abused by local authorities. It's kind of why I would describe an officer in that sort of position as a perpetrator of gatekeeping, because that's really what's happening here. Shannon.
Yeah, sorry, one more thing. It will depend on your local area, but sometimes community mental health teams have a housing specialist within the team. So I know Bedford did at least for a little bit. I don't know if they still do. Um, and again, like my don't ignore any of the other advice, but it'd be worth talking to them. It does obviously depend on their level of training, but yeah, potentially citizens advice as well locally. Sometimes they have housing advocates. It's just worth if you can't get that legal aid route to try and help you do this because this isn't an easy fight, like you've said.
Yeah.
Could
Cool.
I just add something at the end of
Yeah, go
that
for it,
as
Will.
well? I think I've said this before, and I'll probably say it again. But the I think that the gravitational forces in the way that local authorities deal with these sort of cases is towards gatekeeping, because that's ultimately what they're trying to do, is to stop having to give away accommodation, which they wouldn't otherwise have to. So the problem with, like you were saying, Mike, that somebody who's under the crisis mental health crisis team, you couldn't see how they could make a decision they're not in priority need. The trouble is, I can almost see it now, that they'll say, "Well, you're under the team, so you've got the support you need. So if you do become homeless, they can help you. What's the problem?" And if you look back to the history of priority need, you'll see that the courts have to step in on a regular basis because local authorities drift off into the realms of absolute absurdity. And if you remember the background to HOTAC, they were saying that the test for vulnerability, which was that you're likely to suffer harm or injury which an able-bodied person wouldn't suffer from, they were adopting policies that said you only had to be compared to an ordinary homeless person. So then the court said, of course, that's not what the test is. But they drifted off. But unfortunately, in Hotak, was it Hotak where they said about coping with the effects of homelessness? That's where this language crept in, um, which is actually harmful in a way because it opens the door for them to say, yeah, you may be in a terrible condition, but you can cope with the effects as you can go to hospital if things get bad. So the danger is that they will. I mean, it's like that thing, can they do this? They shouldn't, but they will. And I think that they'll ignore. I mean, the problem is you do need to, as you say, get challenge this because what can you do if they just ignore all your evidence and do a letter saying everything's fine because you can get help from a crisis team? Um, you're stuck. You do have to challenge it legally, I guess. So
Yeah,
I'm sorry to have to say that because obviously the problem is there's not enough lawyers out
yeah.
there.
I mean, if we go back to Hotak as well, because Hotak, one of the various things Hotak did was also establish the idea that a council can take into account the support that's available. In that
Yeah,
case, it was his brother who was with him 24/7. But when they made that decision, they gave the warning that if a council's going to try and advance the argument, they need to be sure that that support will be dependable and consistent and actually deal with the actual risk. So if you've got someone who has high levels of anxiety, and that might well present more in the night when they're rough sleeping or something than it would do in the day, then actually the fact that they can go back to the crisis team the next day doesn't help them at all. So that would be the kind of the antidote to that argument. I mean, in the same case, so that Hotek case was conjoined case. There's another case in it called Kanu, and Kanu, they tried to make the same argument, and his case, I think he had like a heart condition or something, and essentially the judges said that, yeah, whilst he did have a family who loved him and looked after him, that didn't wipe out, that didn't eliminate the possibility that he might have a heart attack. Again, read the full judgment to actually, I guess it's been a while since I read it, but that was the gist of it. So yeah, I think yeah, it'll probably be in their template letter that they use that will literally say insert the support that's available to them and then make the argument that they're going to be fine. And that's kind of the way the templates are actually written. So yeah.
can I
Um,
just make one other point? I'm sorry to
yeah.
keep
No, so it's,
going
it's,
on,
it's a
but
really good topic to go into detail on.
because one tip I would give, other than try and find a solicitor, but oh dear, there aren't any, is if you do have mental health problems and you feel that these are being ignored, and you do get to the stage where you are either suffering at the prospect of becoming homeless or you were made homeless, do consider going to A&E. I know this may sound dramatic, but if you go there and report that you're having some sort of crisis as a result of this and you can't cope, it's not that you'd get necessarily get sectioned or something, but you may then get medical people recognizing that there's something wrong, which may open doors to you. Because I've been dealing with quite a lot of people lately who've been admitted to mental hospital and not through sectioning, but just voluntary admission. And then there's a lot of support that's available, and you actually get people. I mean, I've had people just writing letters, really useful letters, saying yes, this person is really suffering, and these are sort of qualified social workers within the NHS or psychiatrists. So that's really helpful. And so do try and do that. I mean, and also they may give you somewhere to stay temporarily rather than be on the street. So that's a bit of advice.
Yeah, I think it adds to the amount of evidence that's available. I mean, I think so. I can remember a time I went into A&E with someone who was actively suicidal, and they had to kind of explain their situation through a thick pane of glass at reception in front of all the people queuing behind them. So it was a highly unpleasant
Yeah.
experience for them, but it is worth it to kind of get that additional assessment or that additional information. So yeah, yeah. So hopefully it's been helpful for this person. But yeah, it's as I say, for charity workers out there. I've been raging this week about charity chief execs and stuff like that for various reasons. But councils only get away with it because charities know it happens and don't do anything about it. So that's one of the reasons why it happens.
I think judges have a bit of responsibility as well.
Yeah, yeah, yeah. Yeah, I think we yeah, as a society we allow it to happen, but that's another issue. Cool. Next question. So a person is waiting for a Section 204 appeal at county court against the local council because of unsuitable accommodation and mobility problems. The person has been in contact with the local councillor. The councillor did send an email with an inquiry to the housing team, which included a letter from the GP, which clearly states that accommodation is not suitable. It already caused worsening of the leg injury and recommendation of better accommodation. The councillor didn't receive a reply to the inquiry within 3 weeks, so sent another email asking for an update as soon as possible. Can the councillor help to resolve this? For example, will the council consider the councillor's email as serious? Would it be a good idea also to meet up with the councillor at the local library and show the pictures of accommodation, explain it briefly, or is it best to wait for an email reply? So, a couple of questions in there. So, firstly, councillors absolutely can be very helpful. And it kind of depends on the individual council culture, but certainly when I worked in Bedford, and it appears to still be the case, when a councillor makes an inquiry, everyone drops everything to respond to it, and they run around like headless chickens for a bit to actually kind of get an answer out that kind of tries to get them off the hook. Now, not every council is like that. As I say, it's down to the political culture there, but it absolutely can do. So the answer is yes, a councillor can help resolve it. And would it be a good idea to meet up with the councillor? Absolutely, yes, because when you meet a councillor face to face, they see you as a human being. If you're showing them photos of the kind of the accommodation and so on, it gives them a reason to care. Because bearing in mind, a councillor probably has hundreds of emails coming in every week asking for a range of things, some of which are trivial, some of which actually matter. This is obviously something that matters. So yeah, meet with them and kind of try and build a rapport with them because I think they're just more likely to pursue it. That's the bottom line. So yeah. Anyone else want to add to that bit? There is a bit more to it. There's a second part to this question which I'll put up there now, which is as follows. I think we've had this question or similar one before. So the person has had a change of solicitors in September. Because the previous solicitor was not responding or ignoring a person, can it cause a lot of delay in terms of the actual court hearing? If a person also asked the solicitor to apply for interim accommodation pending the appeal because of current accommodation actively harming health, if the solicitor refuses, can a person request them to provide a detailed explanation for the reasons of the refusal? Um, so I might leave this one for Will and Karis really in terms of that do solicitors have to give like a kind of a rationale for why they might refuse to take a particular action? So I mean, because there might be several reasons why this might be the case. One might be the solicitor doesn't see kind of merit in doing so. Another reason might be the solicitor's lazy and can't be bothered. I guess there might be other reasons as well. But yeah, what do you think?
Shall I? Do you want to? Oh, Karis, you go. I see one of these.
I absolutely don't mind. But firstly, the change of solicitors shouldn't interfere or cause any delay with the court hearing because it's a different time track. So you're now, once you've put in the papers to the court, you're on their timeline. So they have to give directions, and the new solicitor will be aware of that because you would have put an inquiry and your paperwork in that you've already served the papers to the court. So you're on the court timeline. So it shouldn't cause any delays there. And if you ask the solicitor to apply for interim accommodation pending the appeal, so it would be how strong a case you have on that. So how strong a case is, and it's a different like argument to what the appeal is in the court you already have process. So your accommodation is unsuitable. So they'll be looking at what level is unsuitable to the facts and merits of your why it's unsuitable for you. If, for example, you're in a high-rise building and you can't use your legs, and the lift isn't working, so therefore that accommodation is unsuitable for you, because you can't get down to the shops, you can't get to the doctor and things like that. That's a strong case to move you, and if they don't move you, that can be challenged by way of judicial review. So it would be a different court hearing, but they'll explain everything to you in letters and explain a reason if they don't think you have enough merits to challenge the suitability of the accommodation you're currently in.
And is that something solicitors have to do in terms of a code of conduct, or is it just good practice to explain to a client why they aren't pursuing a particular course of action?
Yeah, it's kind of our job, like to explain what your case is good and what is bad. Sometimes we have to give bad news, and they'll say, well, sometimes the point that they'll say, I've got loads of facts, but it's like an emotional it means something to them. Like if they're losing their house, but it's really unsuitable, but they've lived there for 60 years, but the house is falling down, like it's got subsidence and there's structural damage, and the council are saying, no, we have to remove you because it's dangerous for you to live there. But that person doesn't want to move. And we have to say, well, your refusal to move is kind of, there's no law here because they have to remove you. So the council has, it's a danger to life. You have no defence to this possession if it comes to possession. But we have to explain the good, the bad, the ugly. As solicitors, we have to say everything, and explain to them where you understand, so that you understand what your rights are, and what the law is and how it applies to you. So often you'll get people and they'll say about it's against their human rights and things like that. And it'll be like, well, housing isn't a human right in England. That's an emotional way of looking at it and things like that. So we have to say the law is the Housing Act, and this is about your housing situation. It's not about your right to life, your right to family life and things like that. Although it does come into it sometimes with the Equality Act and the public sector equality duty.
It's an interesting point you're making there, Karis. I know it's not, well, it's kind of it's going on a slight tangent, but it's a useful one because I don't often hear it, but I do sometimes hear it when people kind of go off and want to say, the council's like, breaching my human rights. They have to give me a house, and actually, seems to be a common misunderstanding. It's a bit like, when people say, oh, they've got a duty of care to me, and actually they don't legally have a duty of care.
Yeah.
So that gave me a bit of inspiration to do a video about that at some point, but I'll leave that for now. But yeah, thanks, Karis. I think we've answered the question there. So yeah, that was good. Which brings us on to questions from the live stream. By the way, if this is helpful, guys, do feel like giving it a like and a share and all that sort of stuff. If you haven't subscribed yet to the channel, if you do, you'll get notifications and new videos. You might have noticed I've slowed down quite a lot quite recently because there's a lot of stuff on. Some reason it's called white text. Hold on. There we go. So yeah, if Move On Team contacts someone and does affordability check for nomination for a permanent accommodation, how long could this take? It's been a month and no offer. Unfortunately, there's no hard and fast rule on this. Although, um, if my gut reaction to that question is that if you've kind of done all your bits and you sent it all off and you've not heard anything for a month, that says to me kind of that it's less likely it's going to come through, because generally speaking, if the stars are aligning for a council and they've kind of got all the paperwork, generally something will happen quite quickly. Bearing in mind they're probably, if you're in temporary accommodation, they are motivated to get you out of temporary accommodation as soon as they can. So I'm not, we can't give like a hard and fast thing, but I would say the longer it's going on for, the less good it looks. But I think it doesn't really matter. The answer is always going to be chase them, ring them up, be polite, just kind of explain it. You want to know what's happening. What is there an update? And see what comes of it. It's certainly not impossible. Don't get me wrong. Because I'm not saying that there's no chance. This is definitely fallen through, but I just think generally, at that point in time, the council's motivated. It could also just be sheer incompetence as well. So it could literally be that it's in the council's interest and they've just messed up. So just that could also explain it. But yeah, Shannon.
Yeah, I was basically just reiterating your point. I've seen it before where people have had to sort of wait 1 month, then 2 months, then 3 months, and then 4 months, and that's all because like the right certificates haven't been done and engineers have been off sick or assessors or whatever. And it's literally like a paperwork thing. But like you said, like just ask. And like a non-confrontational, be like, oh, I'm excited. Like, is there anything I can do to help speed this up? And you know, yeah, that was it really.
Yeah, cool. Next question. Does bidding weekly bring your numbers down? So again, uh, difficult to give an absolute answer to this, but in kind of general terms, yes. Uh, might be worth going off a bit of context here. So if you make a homeless application, or if you just apply to the housing register generally and you meet the criteria, you will end up in some kind of band, band one or band B or band bronze or something, and you will effectively be competing with everyone else on the same banding as you. But effectively, again, I don't know of councils that would do it differently, but I think there might be some, because some councils still use a point system. but most councils use a fairly basic banding system, and therefore most councils will have a system essentially where if I was band B and I've been band B since the 1st of July 2025, I will beat everyone who was band B after that date, but I'll be beaten by everyone who was on there before that date. So that kind of gives you the general gist of how it works. However, when you get closer to the top of the list, other things can happen which are quite unpredictable. So you might, it's not unusual. That it's not that unusual for people to be fifth on the list. They finish fifth on the list when they bid for somewhere, and they're the one who actually ends up getting the property because there is some degree. I mean, I call it cherry picking. Might be a clumsy term, where that there's kind of like a short list almost of kind of people who might meet the criteria, might be good tenants, and then it might be the housing association that actually kind of has that final decision. So yeah, you will work up the list over time for sure, and there may also be rules within the housing policy in your area which requires people to bid. So again, I'm not quite sure how this works in practice or how regularly it happens, but certainly some councils will have a policy which says if you don't bid, we're just going to stick you on auto bid. So in one sense, I think the kind of general rule would be if you're on the bidding system, you need to be actively bidding on any suitable property on that list every week. But again, kind of what I'm saying here isn't absolute. There are different councils that do things in different ways. But yeah, kind of the short answer to your question is yes. But there are other things at work in that situation that would make it unpredictable. So yeah, again, I don't know if anyone's got any other question, any kind of answers to that. But that was my attempt. If not, we'll go to what is at the moment the last question. So oh yeah, sorry. Oh, hold on a sec. I know I'm being annoying here. I know I'm doing it. I'm just going to remove the question. So again, this is the idea that we're not. I know I also missed the first question on this as well, but we're anonymizing things here. Now I've put it on here, so I'm just going to stick with it. But this person has been awaiting housing help from a council, been diagnosed with PC. I don't know what PC is. Polycystic ovaries. I don't know. They know about this and they're taking a lifetime to help with housing. They did put me in temporary accommodation. I'm not sure what the question is there, but I think the answer or a comment on it would be yes, that's not unusual. In London Council, certainly some London councils, it's not unusual to be waiting decades in temporary accommodation. Whereas outside of London, in some areas, it's very quick. It can even be days or weeks sometimes. So yeah, I'm not quite sure what the question is there. But yeah, as I say, that may not be unusual at all. That might be on par for the course. If you go on a YouTube channel and you search for how long does it take to get housed or something like that, there's a video I did with kind of average waiting times for people owed domain duty. Now you do need to watch the whole video in detail because there's some important caveats with that. But that kind of it certainly gives you an idea of just how much it ranges around the country and how, how some areas are really kind of stretched for housing and some areas actually relatively aren't at all. So yeah, that's it, guys. End of the live stream. We'll be back next week. Check out Eventbrite for free webinars. Yeah, but hopefully this has been useful. Keep the questions coming.